Okay. Gotta go on the record for the. Scratched out.
And that one was scratched off, but they changed the line.
Oh, which one?
Atkinson. That one scratched off what they wanted.
Oh,
And
something.
for Mr. White.
On the record in the matter of the people of the state of Michigan versus Kennedy Atkinson, file number 24-02062, council appearance.
Anderson, on behalf of people. Toby White, on behalf of Mr. Atkinson. Good morning.
Good morning. Today's the date that was set for a probable cause conference. Mr. Atkinson is present via Polycom from Macomb County Jail. Can you hear us, Mr. Atkinson?
Yes, I can.
Okay. And so, are we continuing to examine this?
Judge, we're continuing to examine. I believe Mr. White would like to address bond. I'm glad you called it first because, boy, I think Mr. White was staring a hole in my head. He was so anxious to get this case called. So I have no, in fact, I anticipated Mr. White would likely want to address bond. So with that, I'll defer to Mr. White.
Thank you. This is a factually messy case. We've got mental health issues, but the mental health issues were resolved with a 10-day stay at Stonecrest. They've released him on proper medication. And I think the protection of society and protection of the alleged victim in this case can be accomplished by tethering him either to his grandmother's or his father's. They are in the courtroom, I should point out. Grandma is alive, well, stable. He's lived with her before. He will follow her directions. He will stay on his proper medications, and we can put him on house arrest and tether him to the house. We're not wanting him to be running out and going around, but I think it'd be better for him mentally to be in a stable situation at a home that he's resided in before. She has no firearms in the house, and the case is messy because the charges are quite serious. But there are several recantation statements that have already been made by Nicole, who's the alleged victim in this case. And so I would say, at least pending the exam, if we can tether him to his home, that would be sufficient to protect society. He does not have an extensive criminal background, so we don't have any grounds for thinking that he won't appear.
Mr. Stevenson.
As much as it pains me to say, I largely agree with Mr. White. I mean, it isn't always
Don't
the
hear
case.
that often.
It isn't. I'm not sure I'm ever.
I don't think I heard you. Can you repeat that?
I'm not sure I've ever gone on the record and actually said that, Judge.
I don't know that I've ever heard of it coming from you either.
Mr. White, I guess to his credit, hasn't gone too much into the facts. However, I would echo that the circumstances surrounding this are, for the lack of a better phrase, messy. But as Mr. White sort of ended, in anticipation of the examination, or up until that point, where all of the facts can actually be presented to this court, I think that's a fair way to frame this, or contextually frame this. As it relates to the bond request, I certainly don't know of the circumstances, particularly the Mr. Atkinson's I think he said grandmother. I have no reason to contest what Mr. White has presented to the court, in that Mr. Atkinson can stay with his grandmother, that she doesn't have firearms. Again, I don't have that information. What I can provide to the court is, at the present state, Mr. Atkinson's bond is effectively denied. There is no bond, and Mr. Atkinson doesn't have any criminal history. A firearm was alleged to have been a part of this circumstance. Mr. Atkinson was petitioned. I suspect that the firearm has since been removed in some way, either under an IRPO order or some other fashion. So presuming that that isn't a further issue as it relates to how the court would like to address or handle Mr. Atkinson, if it is in fact a GPS tethered to his grandmother, I will defer to the court on that.
Who's his grandmother?
This is Alan. Alan, please stand up. Address the court.
How are you, ma'am? I can't hear you.
Well, thank you.
Thank you. And you're Mr. Atkinson's grandmother?
Yes.
And you live in Lansing?
Pardon me?
Do you live in Lansing?
Yes.
And so you are comfortable with him residing with you under house arrest?
Yes.
I muted it before I asked you that. And so, and what Mr. White says as it relates to access to firearms in your home, it's accurate. What he said's not accurate?
I said there were no firearms in the house.
No, there's not.
Oh. Based on the circumstances, and again, I don't have his criminal history, but Mr. Stevenson is indicating that there is no prior criminal history and that there's already been I guess the mental health aspect has been addressed.
Yes, Your Honor.
Okay. And just is Mr. Atkinson employed? Says he's self-employed?
I believe he was, but at this point in time, he's not going to be able to be employed while he's under house arrest for the next week. So we can pick that up,
Okay.
depending on what goes on at the exam.
Bond is amended to 100,000 personal recognizance with GPS tether and 24-hour home arrest. He's only to leave the home for the purposes of coming to court.
Thank you, Your Honor.
The no contact order for the alleged victims will remain intact, not to have contact directly or indirectly with those parties. Again, Nicole. Nicole Balzer being one of those alleged victims, and there is also a victim, initials JC. Not to be within 2,000 feet of wherever they are. Do you understand that, sir?
Yes, I understand.
I'm sorry?
Yes, I understand.
Do you have any questions about your bond conditions?
Yeah, I didn't hear how much you said it was set for.
That's 100,000, but it's personal recognizance with GPS tether and 24-hour house arrest.
So does that mean I only pay if I break my bond conditions?
If you break your bond conditions, your bond's going to be revoked. You'll be remanded back to the custody. Okay?
Right. Okay, yes, ma'am.
Okay, so also out on bond, you're not to possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol or drugs without a prescription. You're not to travel outside the state. You need to report to pretrial services within 48 hours, and you'll be reporting weekly, okay?
Okay, yes, ma'am.
Any additional matters for today's record?
Nothing, people, Judge, thank you.
Nothing for me. Thank you, Your Honor.
You're all set.
Thank you, Your Honor.
On the record in the matter of the people of the state of Michigan versus James Lyons, is it? Or yeah.
Judge?
No?
Well, this is a matter being handled by Ms. Smith.
Okay.
But I think if I understand the context, I think I could probably step in and handle it.
Okay.
I mean, I have
Sounds
a
good.
bit of experience, but we'll see.
If not, then
See
we'll
how
just
well I
mark the
can wing
record
it.
and let you tag her in.
That's fine.
Okay, sounds good. 24-02146, council appearance.
Andrew Stevens on behalf of the people.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Leggins, who appears today via Polycom from the England County Jail.
Okay, Mr. Leggins, you can hear us, correct?
Yes, I can.
Okay, today was the date that was set for probable cause conference. And this matter is scheduled for preliminary examination next week, August 9th at 8:30, and we're continuing to exam, or no?
Judge, it's, in speaking with Ms. Smith, it's my understanding that the Public Defender's Office has a conflict, and this matter needs to be referred for conflict counsel and effectively reset. But that's the best I know, so I'll defer to Mr. Palmer if I need to fill in or he needs to fill in any additional details.
That appears to be accurate, Judge. And unfortunately, this is a conflict that was not immediately apparent. This is, I'd already met with Mr. Leggins, had prepared. We were intending to leave the matter set for preliminary examination next week. In the last 24 hours. It's not the conflict that normally comes up through the course of just reviewing discovery. I don't want to go into more detail than that, but within the last 24 hours or so, this issue has arisen. And I don't see how we can maintain representation of Mr. Leggins.
Okay, sounds good. So I'm assuming your office will be able to make that appointment by next week, so holding another PCC wouldn't work.
I would imagine that, yes, I would imagine that we could have the conflict counsel put in place relatively quickly. Where we go from there, I guess I'll leave to the discretion of the court, whether it wants to schedule for another PCC or what, with whoever that new counsel will ultimately be.
Okay, so we'll treat next week as an additional probable cause conference, and we'll adjust the timeline at that point.
Thank you.
Thank you. Any additional matters on this record today?
I have nothing further, Your Honor. I don't believe I can argue bond for he's being held on.
Very good. Okay, you're all set for today, Mr. Leggins.
I say something?
Excuse me?
Can I say something?
Sure.
I got a $2,500 10% bond. That's a reasonable bond. But I'm sick. I just had an operation on my eye because I went blind in my eye last year. They just had an operation 2 weeks ago. And when this one here get done, they're gonna start on my right eye because it's the same way. I'm a diabetic and they're messing with my kidneys, and the medication will also mess with my kidneys if I don't drink enough water. I'm high potential. I'm trying to get home with my kids. I mean,
You're trying to get what?
I'm trying to get home to my kids. I live with my daughter and my grandkids. I'm just trying to seek in the bond, get a little lower. I had never jumped bond, none of that.
Bond is 2,500, 10%.
Yes, ma'am.
I'm not amending that. It's more than reasonable.
Because I just don't have that kind of money right now.
Excuse me?
I just don't have that kind of money right now.
Okay, and he has other bonds as well?
Judge, it's my understanding, he has 2 other pending cases with Judge Aquilina, I believe. Our office does not represent him on those other files. He's
Okay.
represented by the Abood firm
Got it.
on the other 2 files, but I believe that there is now essentially a bond violation for the conduct that's conducted in the cases for this.
Okay, okay. It sounds like you probably want to address those other issues, because even if I amended this to a PR bond, it doesn't sound like you're getting out. And if I amend it, you won't even approve time on this if I PR'd you right now.
What do you mean about violation?
Meaning that you have a bond on another matter before Aquilina that you violated allegedly.
I think this case is
This picking up this case would have violated. Do you have another case pending, sir?
Yeah, just
Yeah, so if you're out on bond, you don't get to pick up new cases because then it's considered a bond violation. So that's what we need about bond violation. You got to go address that first, and then we'll see you next week. If that's addressed and clear, then we can address your bond here next week, okay? You're all set. Thank you. Which one is the Attorney General? The Attorney General.
What was that? So,
I'm sorry?
what was that? The Brandon
I can't hear anything that you're saying.
Knott. Brandon Knott.
Oh, Brandon, that. Oh, he's not. Okay, on the record in the matter of the people of the state of Michigan versus Alexis Faith West, file number 24-02144, counsel here.
Andrew Stevens on behalf of the people.
Karen Robinson, Assistant Public Defender for Ms. West.
Is Ms. West present?
She is.
Today is the date and the time that's set for a probable cause conference. This matter is scheduled for preliminary examination on August 9th at 8:30. Are we continuing to examine?
Your Honor, this will be a waiver.
Mr. Stevens,
Yes, Judge.
it's a waiver of the exam?
Correct.
The people waiting?
Yes.
Okay. Is there an offer at all?
Judge, the offer that I conveyed to Ms. Robinson via email yesterday was to plead with both counts of resisting obstructing a police officer, and that the people would have no objection to a petition for treatment under the Home Physical Training Act.
I go in, then I go back.
What's your name? What's your name?
Kevin,
You said your name was Brandon? Oh, Mr. Chapman, Mr. Chapman,
yes, ma'am.
did you speak to your attorney before today?
No,
Have you ever spoken to your attorney?
yes, ma'am.
Question was, did you speak to him before today? Okay, okay, so my question was, did you speak to him before today? You said no, so you did speak to your attorney before today.
Oh, I'm sorry, I didn't hear you, ma'am. I'm sorry about that. Yes, ma'am. I talked to him yesterday.
Okay, yep, he said that you're gonna continue to your exam next week, so you're all set.
That's all good to go.
You're good to go, thank you.
Thank you.
You're welcome. Okay, so again, the offer was to plead guilty to both counts, no objection to treatment under HYTA. That offer will continue with you to the circuit court. So you want to waive your preliminary examination, ma'am? Okay, you understand the purpose of the exam?
Yes.
You have the right to require the prosecution put forth evidence after your preliminary examination that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crimes alleged. Do you understand that?
Yes.
You're willing to unconditionally give up your right to an exam?
Yes.
Anybody threatening you to do that?
No.
Any promises being made to you to get you to want to waive your exam?
No.
Find over date's gonna be August 14th. That's not a date that you need to appear in circuit court. That's the date that they're gonna get the file from the district court, okay?
Okay.
Your next court date will be a pre-trial, and your attorney will be made aware of that. Has your address changed since July 19th?
No.
Bond was set at 10,000, personal recognizance with conditions that will continue. Any additional matters for today's country?
Nothing from the people, Judge. Thank
No,
you.
Your Honor.
You're all set.
Well, your paperwork.
Who's in the jail?
Not.
What's your name? Mr. Knott?
You can have that.
Ms. Donnelly, are you representing Mr. Knott?
I am, Your Honor.
We ready to proceed?
Yes.
Okay, on the record, in the matter of the people of the state of Michigan versus Brandon Knott and file number 24-01941, counsel appearance.
Christy Berta from the Attorney General's Office for the People.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant who is appearing separately from the county jail by video.
Okay, Mr. Knott, today's the date that's scheduled for probable cause conference. The matter is set for a preliminary examination in this court, August 9th at 9:30. Are we continuing to exam?
Your Honor, I just got the discovery in this. I'm not looking, I don't think we're expected to run an exam, but at this time I haven't, I haven't discussed it with Mr. Knott about waiving it, because I didn't, when I talked to him, I didn't have the discovery at all. But
I'm gonna treat next week as a PCC.
More than likely, yes. In fact, well, either way, we'll decide by then whether we're gonna waive it and have it go up. So we can treat it as a PCC, because I don't really expect to have any misses.
Okay, so we'll treat next week as a PCC, so the AG can appear via Zoom.
Thank you, Your Honor.
Any additional matters for today's record?
Yes, I'd like to address bond.
Bond is set at $5,119.70 cash only.
Yes, Your Honor.
I believe there's circumstances to warrant deviating from the statute.
Well, I've talked to it with the AG and they are not going, they're objecting to this request, but Mr. Knott would not have any other means to pay off his debt if he doesn't have an opportunity to earn money to pay it off. He struggles. He was incarcerated last year, so he works in seasonal type of landscaping and construction type work. So getting back on his feet, he had to find housing first. So rent, all our stuff kind of takes precedent, but he cannot pay off any of the debt. He doesn't have any assets. He doesn't have any other means to help him pay off the debt except for himself. So we're essentially remaining incarcerated. He won't have any way to pay it off, and he will just be accruing more. So Your Honor, we've asked if at all possible to lower the bond. If not a personal cognizance bond, he reports to me that he has less than $1,000 to his name. He could come up with probably 900 right now.
Did the assistant AG want to respond?
Yes, Your Honor, we would oppose any modification. It was already set at 25% pursuant to statute. And frankly, the arrearage has just gone up. There has never been a good payment history as evidenced by the very large amount. He's never paid in a single year since 2017. He's never paid as ordered. And frankly, 9 prior show causes have not made any impact either. So I don't see any reason that the claim that he's going to obtain work and pay constitutes good cause. So I would ask the court to deny the motion.
For the reasons indicated by the assistant AG, the motion is denied. Bond is set per statute $5,119.70 cash only. Any additional matters for today's record?
No, Your Honor.
No, not offense.
You're all set.
Thank you.
You can go there. Michael Gobble Lobster is present, correct?
Yeah.
That's Mr. Moakes' client, so we need Mr. Moakes. Samuels, is he in the courtroom?
He is, he has 2. He has Raymond, Baldwin and Rice. I think your staff just went to get
Okay,
his
yeah.
Rice, but I can see,
If he's ready on Baldwin, we can do that.
yes. May I go
Yes,
find him?
please.
Thank you. Yeah, Baldwin.
Well, who's in the jail?
Joshua Newton.
Say that again?
Joshua Newton.
Thank you. Ms. Donnelly, that's your client. Are you ready on him as well?
Yes.
Who's Janice Blow?
I am.
Are you here for a court case?
LVNV versus Cade.
Well, they said that they submitted it in my file. It's in your church file.
There was a step to adjourn.
Yes. for
Did
that.
you file a step to adjourn?
Yes, I did.
Okay, well,
Tell
then
me
you're
it
all
had
set.
to-
I'm sorry?
Excuse me, I didn't mean to interrupt.
Yeah, if you filed a step to adjourn, you're all set for today.
Thank you very much.
Thank you. On the record in the matter of the people of the state of Michigan versus Raymond Baldwin, file number 24-00693, council appearance.
Peter Stevens on behalf of the people.
Matthew Samuels on behalf of Mr. Baldwin, who is approaching edges.
The date and the time that was scheduled for probable cause conference. Let's see, actually it's scheduled for an exam, it says. And are we waiting?
Yes, Judge, it's my understanding that Mr. Baldwin will unconditionally waive his right to the preliminary examination, as well as the people will also waive their right.
That is true and accurate. Your Honor.
Is there an offer?
There is, Judge, the offer extended to Mr. Samuels, via email, I think earlier in the week, was for Mr. Baldwin to plead guilty to count 2 and count 3 of the felony information upon successful plea and sentence to count 2 and 3. People move to dismiss the balance of the information, and this all must occur by the first scheduled circuit court pretrial conference.
That's complete and accurate.
It is, Your Honor.
Counsel. Yes, please. Okay, and so Mr. Baldwin, you understand that you have the right to have a preliminary examination in this file here in the district court?
Yes, ma'am.
And you're willing, or you want to waive your exam? Okay, understand the purpose of the examination? You have the right to require the prosecution to put forth evidence that would establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am.
Anybody threatening you to get you to waive your exam?
No, ma'am.
Is there any promises extended to you that entice you to want to waive your exam?
No, ma'am.
Trying to waive to be freely and voluntarily given. You find over dates August 14th. That's the date the circuit court will get the file from the district court. That's not your appearance date at the circuit court, okay? Your appearance date will be for a pre-trial and you and your attorney will be notified of that, okay? Do you have any questions? Bond was set at 5,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing for the people, Judge. Thank you.
Nothing, Your Honor. Thank you.
You're all set. On the record in the matter of the people of the state of Michigan versus Joshua Robert Newton, file number 24-02184, council appearance.
Andrew Stevens, on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Joshua Newton, here appearing separately by video from the Union County Jail.
Mr. Newton, today's the date that's set for probable cause conference. You do have a preliminary examination before me on August 9th at 9:30. Are we continuing to examine?
Yes, Your Honor, I would like to address bond.
You can address it at this time.
Thank you, Your Honor. The bond was set at 5,000 cash surety when he was arraigned. He's been in custody for 11 days. Your Honor, he does have, I can't remember. I've represented Mr. Newton before, and a couple of years ago. At that time, it was my understanding he didn't have a criminal history, but I can't be 100% sure about that today. But I know that it's, if anything, it's limited. But what I'd like to ask is for a personal cognizance bond. His mother is here. Dee Newton is in the courtroom. She lives at 1140 West Maple Street in Lansing. And Josh lives with her as well as his father at Magnolia. So I'm sure that she assures me that Josh can return to her home and she would comply with the bond conditions there. Your Honor, I do know that he's not currently working right now, but like you said, he is from Lansing. He's lived with his mom his whole life. His dad has recently gotten into his life. And so I'm sure that with a PR bond, he can follow the court's orders and follow no contact order, Your Honor, and appear in court. He had no issues appearing in court last time when he was before you. So thank you.
What's his mother's name?
Ms. Dee Newton. Just Dee, right? Yeah.
Stevens, you can.
Could I get a repeat of where Ms. Newton
1140
lives?
West Maple.
Thank you.
Yeah.
And I have a bond for recommendation that does indicate that he has at least another matter pending in 55th for a charge of making threats of violence against the school.
Yes, I do. Yes, you're right, Your Honor. I forgot about that. Yes, he has a PR bond in that case.
So then there would be at this point at least a presumption that there's a pattern of ongoing violence or words or actions that represent violence towards others.
There is indications we are in negotiations or with the prosecutor in regards to mental health court, Your Honor. Yes, but that allegation is also from, I think, 2022. It's older as well. Let me make sure. I'll look at the charge.
It says
She's correct.
2022.
It's a alleged date of offense of October of 2022.
And then we have four counts of felonious assault here.
We wouldn't be opposed to if the court were concerned about tether or location or where. Yeah, I'm sure he would comply with the court's orders.
I would indicate to the court that as it relates to the 55th matter, Ms. Donnelly is correct. It is a $10,000 personal recognizance bond. So I apologize. I'm trying to do all of this on the fly.
No worries.
Wasn't.
I'm trying to see if I got a report from Katz and I didn't, to see if he was ordered to have an evaluation before he could be released. I think he indicated to, even arraigned by Judge Ward on the 24th, indicated that he hadn't been on his medication. But there was indication that he was to have a CATS or mental health eval before he could be released. I don't have any record that that's taken place. I just checked. So the bond motion is denied until I get that report.
Okay.
So we'll see in August 9th at 9:30. Any additional matters for today's record?
Nothing. Thank you.
Nothing for defense, thank you.
Okay, you're all set, Mr. Newton.
What was the notation from Judge Ward? Just a CATS evaluation?
It says CATS evaluation for mental health prior to release. It said defendant said he needs his meds to have control and he hasn't been on his meds.
Does it have any medication that's like 17?
Okay, well, that's what you reported in the range, so it's your- so
He
you have
doesn't understand. And he has autism.
Well, we'll have to wait for.
Yes.
Okay, Ms. Francis is here on a civil matter. Ms. Francis, which matter are you here for?
Good morning, Judge. I have LVNV funding versus CADE.
Oh, we received this tip to adjourn that, so you're all set.
Oh, okay. We hadn't heard back if it was entered, so I appreciate
I
it.
haven't seen it yet, actually, so it actually hasn't been signed by me, but I was told that you did enter it. I'm going to grant it.
Okay, thank you.
You're welcome. President, I'm going to the other party, yeah. Who's in the jail? I didn't know she was sitting, but we got stuff with it.
Oh, yeah.
Okay, that's,
Probably, yeah.
who's in the jail? Can you hear me? In the jail,
Yes,
what is your name?
Ivan Carranza Delgado.
Is that cool? What is this?
For Gallagher trains. Gallagher trains.
Oh, for cool.
And for bond motion.
And, he didn't need an interpreter, does he?
Oh, so
He does, but.
read straight from this.
He does?
Yep.
Okay.
Don't know if it's necessary.
That's all right. It would be terrific if, you know, the people that I work with put notes in the file.
Yeah.
Right, well, it is necessary. He's gonna put us on.
Yeah. And maybe they could be.
Yes.
Yeah, I ended up going to John Lee this morning.
Oh, this is the one that his tether wasn't paid. It is paid now? Oh, okay. On the record, in the matter of the people of the state of Michigan versus Ivan Delgado, file number 24-00429, council appearance.
Andrew Sims on behalf of the judge. Thank you.
Ashton Gallagher Train appearing on behalf of Mr. Delgado remotely. Mr. Delgado is also appearing remotely from the Ingham County Jail.
Okay, we just set this for a show cause. I think he was remanded because his tether was cut off. We do not have an interpreter, but I was advised that his tether is back on, so I'm going to reinstate his bond. And counsel, if you can make sure your client is understanding that he needs to keep his tether on.
I will do that. Thank you.
Did you need to speak with him privately at all in a private meeting room?
No, not today. I will talk to him when he's released. Thank you.
He's all set.
Thank you.
Thank you. You're all set, Mr. Delgado. Excuse me. Can you let Mr. Delgado know that he's free to go?
Oh,
That's
meet
fair.
Carlos. Meet Carlos.
Oh, can you tell him?
Iván, ya te puedo decir ya se acabó tu corte.
¿No me van a dar fianza?
Sí,
¿Y ahorita te la van a dar a ti o cómo?
sí, ellos me van a avisar. Ahorita te aviso.
Ok, thank you.
McNeese. Ms. McNeese,
Good morning, Your Honor.
morning. Which matter are you here for?
I am here on Cavalry versus Joy Green.
Okay. You're here on behalf of Calvary?
I am.
Okay. Stand with your name? Joy Green. Okay, Joy Green is present in the courtroom. Do you have a device to get on Zoom at all? Okay, in just a moment, we'll get you set up so that you can meet with her privately, okay? Okay. On the record in the matter of the people of the state of Michigan versus Whitney Rice, file numbers 24-01811, 24-01423, 24-01634, 24-01423. Council appearances, please.
Andrew Stevens on behalf of the people, Judge.
Oh, these are the kids. Okay.
And Judge, if, as a roadmap, I think we're gonna have all this wrapped up. And further, I don't know if you called it, and it's certainly not on today's docket, but there's a felony file also that Ms. Schroeder represents Ms. Rice on, that comes into play. I don't know if you called that docket.
That's the one I said 24-01634. That one?
Yes, 61634 FY.
Okay, you said them so fast, Judge, I didn't.
All right, yeah, I know I did.
So there's a little bit of a pivot. I'm
Okay.
still writing up the change. And so like I said, if I could just have a moment, I think we'll get all of these wrapped up.
No worries, we also have to address the competency report.
And that was another part that I want to make sure we address too. Thank you, Judge.
And then we also have to do sentencing, I believe, on one of my cases. If you want to proceed with that, well, that's already resolved. That's just. While we're waiting for everything else to get taken care of on the.
Well,
other
it depends, depends on what's going on before we sentence.
It's my understanding it'll be a guilty plea.
That will wrap up.
It'll wrap up other pending matters.
So we'll hold off on the sentence.
And I figured that's what you would take.
And my thought would be to do competency first, just to get that out of the way.
Yeah, so we'll let Mr. Stevens catch up on his paperwork. And let's see. If you can. We have, you want me? So what? Yes, please, we'll put her on iPad. Ma'am, you're all set.
I just wanted to know, he doesn't speak English. Is there a place where I have to pay for his bond or?
His bond, he already had a bond. The only issue was that his GPS was cut off.
No,
So
it was actually turned off because he didn't make the payment.
correct.
Yeah.
So the GPS is back on. So I reinstated his personal reconnaissance bond, so you don't have to pay post a bond.
Oh, okay, perfect. Thank you.
You're welcome. Let's see.
I need to step away for a few moments to Judge Ward, just so people know where I am, if I may.
Yeah, how long are you gonna be gone? Because we have someone in custody on here.
I don't know. I'll stay here. I don't know how long I will be there.
Okay, well
It's
then.
for another competency.
I've already called your case, so you're on the record.
Very good, Your Honor. Thank you. Oh.
Let's see. Ms. McNeese, I'm gonna put you in room 1, so that you all can complete your, a private discussion, if necessary, to see if you can resolve this before I am able to call the case. I gotta finish my criminal matters first, okay?
Perfect. Thank you, Your Honor.
Thank you. Let's see, room 1, let's see. Mr. Truba.
Good morning, Your Honor.
Good morning. You're here on behalf of Midland Credit.
I am, Your Honor.
Okay, Timothy Holmes is present. I'm in the middle of a criminal docket, but I can put you both in a private meeting room to discuss this and see if you can come to a resolution. If not, then I'll call the case
Sure,
once I'm
Judge.
finished my criminal matters.
Yeah, I'm always up for talking to people, Your Honor. So, yeah.
Okay, sounds good. Mr. Holmes, can you start your video, please?
Yes, Your Honor.
You start your video.
Go to my video. Also ask you to start your video. Okay. Allow.
Are you all waiting for a court date?
Yes, it's Michael Gopal.
Yeah, it's me.
Oh,
Milks.
Mr. No. I saw him. I just don't know where he went and if he needed to go on the record on this one.
I just looking for him.
Okay, sounds good. Mr. Milks, did you need to go on the record for your matter?
I was under the impression, I think that this was kind of taken care of just regarding the transfer to the Fifth mental health board. I don't know if the
My last note indicates there was a conflict with the interview at mental health court, so it was rescheduled.
and that's, I thought that's where we were at, was that it was
That was July 12th.
correct, Your Honor.
So I don't know if these just don't have an update yet.
Yeah, Your Honor, he was accepted, is my understanding at this point, into 55th Mental Health Court. And I do believe the paperwork is going to be put through, and I think the last thing left is just to kind of dot the i's, cross the t's regarding a plea agreement this time. Is that right? If I'm wrong, fine, but that's what I got on the notes.
Judge, he would just not ignore me as much as he does.
It's a pattern I see with Mr. Milks.
I think it's just
That's
me.
exactly what I'm talking about.
Ginger's going at it.
Well, then why would he?
Because
then
this.
I had to say this.
You didn't answer me. We've already dealt with this, correct?
Yeah, you didn't answer. Where's the truth?
No, we just need to get the paperwork in, and then we're gonna be absolutely fine, which is really what I said.
We had the plea agreement worked out, Judge.
We did, and we just need the paperwork.
That's the part you missed.
And we need the paperwork.
Yeah, the plea agreement's worked out. You said it wasn't worked out yet.
So we need to cross the i's, dot the
Plea
t's.
And work
agreement.
out the plea agreement.
Yeah, that's what you said.
I did. That I did.
Okay, so we just need some paperwork.
That's right, Your Honor.
Do we know how long that paperwork is gonna take us? Yeah,
I'm sorry, Your Honor.
and they're gonna take the plea at 55th, correct?
I believe so.
Okay, sounds good.
I'm not certain of all the,
And that's how they do it at 54B, I think. They take the plea over there. So we'll go with that. And then we're just waiting on paperwork.
yes,
So
Your Honor.
you need a new date.
Whenever it's available to the court, Your Honor,
Just need some
it's,
paperwork.
I think if the court wants to set a date just so it keeps Mr. Milks in lines to get the paperwork, then
A
we
control
can do
date?
that.
but just want to put out there, I'm not the one that fills out the transfer paperwork.
How long is it? How? I don't know.
For the paperwork?
We can make sure.
Let's set it for next week,
Thank you, Your Honor.
August
Very good.
8th at 8:30.
August 8th at 8:30. So take care of that for today. Are we ready on rice?
So, Judge, thank you.
Okay, back on the record in the matters of Whitney Rice, I'm gonna take file number 24-01634 FY first. Because we do have a report from the Department of Health and Human Services Center for Forensic Psychiatry dated prepared July 22nd, 2024, and the council, you both received a copy of that.
People have.
Defense has as well.
Okay, the a body in the conclusion of the report opines that the defendant is competent to stand trial. Is there any reason for objections to this body or conclusion of report?
None from the people. The people would stipulate to have the court receive that report and its conclusions.
Likewise from the defense, Your Honor, and I did submit earlier this morning a proposed order for entry regarding competency. I did email that in.
So the court will adopt the report and the conclusion and incorporate it into the court file by stipulation. And that would leave us with the matter of one count of possession of methamphetamine and then breaking and entering without the owner. And then there's going to be a global resolution.
Yeah.
Sorry, Your Honor. Yes, there is a global resolution here that would in short dismiss this file pending a guilty plea and some restitution on one of the misdemeanor files that she has before this court. And I believe Mr. Attorney Samuels can speak a little more to that in a moment.
There's a plea sheet, correct?
I have it in my hand right now, Judge.
So then we'll do that.
Yeah. Good with that?
Yeah.
Okay, may I approach?
Yes.
Recommending, yes.
Yes, recommending that. Yes. Thank you. Just want to make sure. Sliding side. I think I am, but I'm not just a moment longer just to be sure this is a question.
Okay, so file number 24-01811. Where she is charged with one count of arson of personal property. Is that accurate?
That is correct.
Okay, the offer from the people is that she would plead guilty to count one on docket 24-01811. Upon successful plea and sentence, people move to dismiss file number 24-01634. Also recommend dismissal of the PA 53 and docket 24-01423. Sentence to be concurrent to docket 24-01423. Defendant to pay restitution on docket 24-1634. That's complete and accurate.
One addition, Judge, yes, and any restitution, of course, on the sentencing offense is always applicable. So I marked restitution above the plea agreement to be determined for both docket 24-1811 and then by agreement, any restitution on the dismissed felony 1634. Beyond that, the court has it accurately on behalf of the people.
Sounds good. And your client wants to accept that offer?
Yes, Your Honor.
You have an advice of rights.
I do, Your Honor.
Okay, Ms. Rice, you heard the offer completely?
Yes.
Do you understand the offer?
Can you repeat it just so?
Yes, no problem. The offer is that you would plead guilty to count one in file number 24-01811, which is arson of personal property, 200 or more, but less than 1,000. That's a misdemeanor. The maximum penalty is 1 year in jail and or $2,000 or 3 times the value of the property damaged or destroyed. And that in exchange for a guilty plea to that count, that the people would move to dismiss the charges in file number 24-01634, and that they'll recommend dismissal of the bond violation in file number 24-01423, that they're recommending your sentence to be concurrent because you have a sentencing schedule for today, and that you will pay restitution on both files 24-01811 and 24-01634. That amount is to be determined, okay? You need to talk to your attorney.
Okay, Your Honor, we're ready to proceed.
Okay, so you understand the offer? Yes, ma'am. You want to accept it? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? I do, Your Honor. You can put your hand down. Okay, so I do have an advice of rights and plea information sheet here. Just putting this case number on here. There is a date on the second page and the signature. Is that your signature? Yes, it is. Did you read these rights? Yes, I did. You understand the rights here? I do. You're willing to give up all these rights? Yes. Okay, so that means in each of the files listed that you have the right to have the presumption of innocence. So you're innocent until proven guilty. You have the right to maintain your innocence and require the prosecution prove your guilt at trial. You have the right to jury trial. You can remain silent at trial and not have silence be used against you, or you can waive your silence and testify on your own behalf. You have the right to subpoena witnesses to testify for you at trial. And you have the right to see, hear, or question any other witnesses that the prosecution intends to call against you. You understand that? Yes. Mr. Daniels, can you give a copy for her, please?
Sure.
You also have the right to have a jury trial. These are all. You want to give up each of those rights today?
Yes.
Okay. And that would be giving up the right to have them prove each element beyond a reasonable doubt, correct?
Yes.
Anybody threatening you to get you to give up those rights?
No.
Any promises being made to you in exchange for you pleading guilty?
Yeah.
Are you currently on probation or parole?
No, I'm not.
You understand that a guilty plea could result in a conviction that you may need to report on a future job application. A guilty plea could result in conviction that may have impact on where you can travel or immigration status that you might be seeking.
I do.
As to the count in 24-01811 of arson of personal property, $200 or more, but less than $1,000, how do you plead? Are you pleading guilty because you believe you're guilty?
Yes.
A factual basis, please.
Sure, Your Honor. Ms. Rice, on or about June 15th, 2024, were you over at 500 Sprucewood Avenue?
I was.
And to the best of your knowledge, is that in the city of Lansing, county of Hingham?
Yes, please.
State of Michigan?
Yes.
And at this time, when you were inside the property, did you set fire to something inside the property?
I did.
And did you do it intentionally?
I did.
And did this property cause damage to the house in any way, or to personal property inside
Yes.
the house?
Yes.
And what was that personal property? Was it clothing?
Yes.
It was clothing. Was any damage done to the walls or anything like that?
Not that I know of at the time, but it was clothing. Yes.
And do you believe that clothing had a property value of over $200? Are you contesting that it was not less than $200? That the value that the
I'm agreeing with what you're saying.
So you don't contest that the value of the property that was burnt was between 200 and 1,000?
No, I do not.
That's on factual basis, Sharon.
Any questions from the prosecution?
Thank you. Ms. Rice, the 500 Sprucewood address, is that the address or residence of Robert Holder?
It's my home. I purchased that home. He
Okay.
has been living there with me.
All right, and so he was living there at the time?
Yes, he was, but he was not present at the time of the arrest.
Fine, but he was living at that address and had clothing there, correct? And the
Yes.
clothing that you burned was in fact Mr. Holberg's clothing?
Some of yes.
At least some of the clothing?
Yes.
Okay, thank you, Judge.
Thank you. The court is satisfied with the factual basis. I'll accept your plea. I find your plea made freely, voluntarily, and intelligently. Do we need to have a restitution hearing for this to determine the amount?
Judge, I think I would recommend, let's see, because I think the court has already sort of alluded to the fact that you're going to hold off on sentencing for the previous case.
Correct.
I suspect that you're going to refer this case down to probation for a report. I guess.
They just gave me a report on the 26th, so I don't think they need another.
Well, the only thing I would suggest is they're probably going to look into this at least to the extent of restitution.
Okay, I can do that.
And then when we come back for sentencing on this case and the other, we might have a sense of what restitution is or is not before we actually schedule a restitution hearing.
Okay, I'll do that. I won't give them a full referral because what is that, 8 weeks or something? So that they make us give them 8 weeks.
Yeah, I don't think an 8-week delay is necessary.
Agreed. So I'll just set it out and I'll send them the other file down to determine restitution if possible. You've gotten the report for.
Yeah, we were prepared to proceed with sentencing on the previous case, and since there is no restitution on that, I would ask that we go with sentencing on that because it's a 93-day maximum. The surety has 63 days in jail, and the recommendation is for straight jail time.
Right.
So we can just get that case over with. I would ask for time served since she's close to the 93 anyways with good time. And we close out that file and then we can.
We were running a concurrent sentence. Not your plea offer.
I understand that. I don't know how that would affect that
I'm
necessarily.
not gonna sentence I'm gonna do one sentence.
Okay. Then I think I
And I'm
will,
just gonna set this out probably 2 weeks.
so we'd be looking at the 16th.
August 23rd.
I am not available August.
Are you available the 22nd?
I am not.
Are you available at all that week?
The 21st.
Let's just get a prosecutor there. Can a prosecutor be available for the sentencing? If they want to appear.
I'm sure we can make that arrangement, Judge.
Okay.
If nothing else, I probably could
I
be
mean,
here.
there'll probably be a prosecutor across the hall.
Not on a Wednesday.
Oh, that's a Wednesday. I'm thinking it was Monday or something. Okay.
No, we were just going backwards down the week. You asked me about Friday and Thursday, and so I just said Wednesday.
Okay, Wednesday. Do we have anything that Monday or Tuesday?
I could do Tuesday afternoon or Monday afternoon.
Well, who we got going on? Retry? Oh, we can ask. We'll do it Tuesday, which is we'll have a prosecutor.
At what time?
That's the 20th. 9. At 9.
Your Honor, I said I could do it Tuesday in the afternoon. I'm not available. on
So
Tuesday. Or late morning if we want to do it at 11.
I have a dentist appointment that day. So what? So the latest we can do is 10:30.
If I can appear by Zoom, I'll guarantee it. I may come in person, but it's if I have to appear by Zoom.
August 20th at 10:30. See, and then I will send this file. And get it filed down so that restitution can be determined if possible. And get a victim impact. Any additional matter for today's record?
Nothing from the people, Judge. Thank you.
Your Honor, I would like to address a bond on all of this. I am not sure. I know we resolved a lot today.
I'm not amending her bond. All set.
Thank you, Your Honor.
Thank you. Is that all the criminal? Yeah. I don't think I have any more criminal. Was this? Okay, on the record in the matter of Midland Credit Management versus Tim Holmes, file number is 20-03326. Counsel, can I have your appearance?
Good morning, Your Honor. Brian Truba appearing on behalf of plaintiff Midland Credit Management. My P number is 61752.
Okay, let's see. Mr. Holmes, please start your video and unmute your device.
else ask you to, okay.
Okay, today was the date that was set for a hearing, and this is for a motion, for objection, that is to periodic garnishments, and so you met privately. Did you come to a resolution at all, counsel?
We did, Your Honor, just one correction. It's a non-periodic. It's a bank garnishment. But we did come to a resolution, Your Honor, if I could put it on the record, please.
Please do so.
Your Honor, the plaintiff has agreed to release $1,500 back to the defendant. And any amounts above that would come to plaintiff's counsel. Additionally, Your Honor, the parties have agreed to an installment pay order of $40 a week beginning on September 28th, 2024, and continuing on the 28th of each month thereafter until the balance of the judgment's paid.
Correction, sir, $40 a month.
Oh, $40 a month. I'm sorry. Thank you.
Okay, so, okay, how much is being held right now?
Mr. Holmes indicated it was approximately $2,800. We do not have a disclosure, Your Honor.
Total amount was $2,852.66.
Okay, and so you're saying that the agreement is to release $1,500 to the
defendant, Your Honor.
And that I need to modify this order here. Okay, is the order, okay, so the garnishee, the order will indicate the garnishee shall immediately release $1,352.66 to plaintiff's attorney. And then the balance could be released back to the defendant. And then you all have entered a periodic payment plan?
That's correct, Your Honor. And if the
what's
court
that
does,
amount again?
that was $40 a week with the first payment date starting on, or excuse me, $40 a month with the first payment date starting on September 28th, 2024.
Okay, I'll note that. I think I need paperwork on the installment payment order, but as it relates to the order on the garnishments, I have one here that I've modified. I'll sign and date that for today. Any additional matters for today's record?
Judge, can I submit that installment pay order this morning? Or would you like it under the 7-day rule, or how would the court like that?
You can submit that. You can submit that this morning through my file.
Okay, very good, Your Honor.
Thank you. Do you have any questions, Mr. Holmes?
No, Your Honor, thank you.
Thank you. You're all set.
Take care, Mr. Holmes. Thank you, Your Honor. Have a good morning.
Thank you.
For criminal docket.
Yes.
Okay.
Thank you.
That's bugging me to dismiss something.
Oh, have fun.
Uh-huh.
Let's see here. I have Miss Green. You can come up, Miss Green. Miss Green, can you come to the table, please? Yes. Okay, on the record in the matter of Calvary SPV versus Joy Green, file number 24-00354, counsel appearance.
Good morning, Your Honor. Hannah McNeese, PA 2477 on behalf of the plaintiff.
Okay, ma'am, state your name for the record, please. Ms. Green, state your name for the record, please. Joy Green. Okay, today's the date that was set for a motion to set aside dismissal. Trying to find the file here in my file. Let's see. Nothing. Okay, the parties met privately. Did you all come to a resolution on this?
We did not, Your Honor.
Okay, so this matter was dismissed. I'm assuming the plaintiff failed to appear to court.
Correct.
Okay. Okay, and why did, I can't access the file, so you have to explain to me what your motion says.
Of course, Your Honor, my pleasure. Yep, so this case was dismissed for lack of process. We did personally serve Ms. Green on February 19th, 2024. I believe that we did file a default judgment, which was rejected, so we are asking that this case be reinstated with an entry of default as well today.
Okay, and why would we default her if she's present in court?
Happy to try to, open a period of discovery as well, Your Honor.
Motion to set aside dismissal is granted. The motions for default is not. She is present. I don't know. Did you file an answer?
Yes.
Okay.
Prior to the April 1st court date.
Okay. So we will have this matter set for a pretrial, and we all can work out if discovery deadlines are necessary. And then we will get you your next court dates for your trial and et cetera at the time of the pretrial. So let me see. Did you submit an order for your motion at all?
I don't believe so, Your Honor. I'm happy to file that on my file.
Okay, thank you. And we can file that. I'll review and sign that today. Any questions today, ma'am?
No.
Okay, any additional matters for the rest of council?
Not today, Your Honor.
You're all set.
Thank you so much. Have a great weekend.
Thank you.
So, Your Honor, then I just wait till the court will notify me of the next.
Yep, you'll get a notice in the mail for your next court date, which should be for a pretrial. If you don't see that within the next 7 days, you contact the court to make sure you didn't miss any mail, okay?
Okay. Thank you much.
No.